I'm going to talk about contractual interpretation and substantive and procedural problems surrounding contractual interpretation. I have been always entertained by this topic as a part of my practical activity as a counselor or as an arbitrator. And I saw a great temptation to look at contracts in isolation without application of governing law and interpretation in complete isolation. But this is not the right, or at least in my view, it is not the right approach. For the last year, I was looking at this topic from the perspective of international investment arbitration, but I'm not going to discuss that aspect. I will rather limit my observations to international commercial arbitration. So the first issue to start and the first temptation which arbitrators usually have is whether interpretation of contracts should be made in isolation, giving logics, some language aspects of contract without paying due attention to applicable law, or whether it should be framed by the language of applicable law. And I put on the slide reference to Ukrainian international private law, because international private law says us that the scope of application of applicable law to the contract concerns or relates to interpretation of that contract. And therefore, governing law does matter for the purpose of interpretation. And if we will look at various national laws in Europe and worldwide, we will see that there are quite dramatic differences between various laws, how they approach contractual interpretation. And those differences were approached and discussed in details, while in Europe there were a number of attempts to harmonize or codify European contractual law, and it was revealed that actually it is quite difficult to provide certain uniform provisions in relation to interpretation of contracts. Since for Ukrainian arbitration court at the Chamber of Commerce and Industry of Ukraine, Vienna Convention is extremely important and I would say quite dominant for the practice of this court, I decided to have a brief look on whether CHG provides us any answer on contractual interpretation. Because it might be also a temptation to apply Article 8 of CHG, which is on my slide, in respect of contractual interpretation, but it is not really clear whether that article was intended to be applied specifically for contractual interpretation. It says to us that it should be applicable to statements made by the parties and their behavior, their conduct. So it might be seen again as a temptation to broaden the scope of this article and to apply it towards contractual interpretation. And actually some commentators, and we do have some practice where contracts are interpreted exclusively on the basis of CHG, on the basis of Article 8 of CHG, and that would lead us to more subjective approach towards contractual interpretation, to establishment of intent of the parties, and to establishment of what is perceived to be by a reasonable person, and the residual part of interpretation. The residual part of interpretation comes to all other circumstances which might be relevant. Just to trigger possibly some discussion, I put on the slide various views towards applicability of Article 8 of the Vienna Convention, or CHG, on contractual interpretation. And you can see that these views are somewhat different or somewhat distinct. Some commentators perceive CHG and Article 8 of CHG to be applicable to contractual interpretation. Others are more skeptical, and since currently I'm working for the University of Oslo, I should mention one of the Norwegian professor, Judita Kardeamos, who is very well known in the context of interpretation of contracts, boilerplate clauses, and many other aspects of international transactions. Her view is that Article 8 is not really applicable towards contractual interpretation, and if it is not applicable, then it would lead us to the necessity to define which national or domestic law would be applicable on subsidiary basis, and which law would govern then contractual interpretation. So just to conclude these short observations in respect of contractual interpretation and application of domestic law or national law or CSG, I just need to stress for my colleagues, I'm sure you are well aware of this, that contractual interpretation is not really in isolation, and even though it might be a great temptation to keep contract autonomous in vacuum and to approach contracts independently from national law, or to approach a contract in accordance with the party autonomy, what the parties have agreed in the contract, and they might agree on some specific approaches towards interpretation. They might have some clauses relevant for interpretation. Still, the contract would be in the frame of applicable law. And now I turn to another part of the discussion, which is contractual interpretation and procedural law and procedural aspects. And even though substantive law matters for contractual interpretation, inevitably, we have a number of procedural aspects surrounding contractual interpretation that are relevant and that are important. And given that for commercial arbitration, for international arbitration, the only possibility to challenge award or to resist enforcement and recognition are procedural irregularities. Therefore, these procedural aspects of contractual interpretation might be quite dramatic. So what I basically want to say, I would like to emphasize that under certain laws, there are certain restrictions called, for instance, and that is only one example, parole evidence rule, which limits the scope of admissible evidences for the purpose of contractual interpretation. And if a contract is subjected to such laws of common system, then it would be treated as a part of substantive law, but at the same time we have procedural law which might come into dissonance with that. And of course every case is specific and it is quite difficult to discuss it in abstract, but it might be well the situation where it would be quite challengeable practice if evidences are excluded with reference only to substantive law, to parole evidence rule. And one of such example is SCC award, which was discussed in literature and was commented a lot. Ultimately, just to say at the beginning, ultimately everything ended well for arbitration in the sense that award was upheld. But anyway, the issue of whether exclusion by the sole arbitrator of certain evidences, which were absolutely correctly excluded under applicable substantive law, which was New York law, where parole evidence rule applied, whether this practice could be qualified as challengeable practice from the context of applicable procedural law, and constitute in such a way ground for annulment. That issue was widely discussed by Svea Court of Appeal. Ultimately, Svea Court of Appeal upheld the award. The award just brings into our attention this gray zone of contractual interpretation and relevance of procedural laws towards contractual interpretation as well. So I just tried to identify various areas where procedural aspects might be triggered by contractual interpretation. For instance, contractual interpretation and jura novit curia, to what extent arbitrators are empowered to interpret themselves and when they have to invite party submissions, how to administer the party submissions to this in this regard. Expert opinions on the point of applicable law and what is the limit and the scope of those expert opinions. So it might be a number of purely procedural aspects which would be absolutely relevant for contractual interpretation. And just to conclude, so I should be quite in time, and yeah, I have 5 minutes for your questions, so probably I will just add this 5 minutes to coffee break. So I will be then probably the hero speaker for this conference. So my conclusions are quite simple, but I would say they are extremely important. Governing law or applicable law to the contract matters for contractual interpretation, and actually that law defines the frame of contractual interpretation. Procedural law elements are relevant for contractual interpretation, so I'm not saying strictly applicable. It would depend on various situations and should be decided on case-by-case method. But it is absolutely relevant. And in terms of CHG, it is an open question. Thank you very much, and I'm looking forward to your questions.